Greetings, this is Management 430, Human Resource Management, and we are going to be covering legal issues in compensation and benefits. So you are aware, obviously, employment law covers a wide category of things. We've already addressed EEO law when hiring and managing of employees on a daily basis. There are specific laws regarding compensation-related issues that we will get into here in a little bit. Again, we want to make sure that people have knowledge so that when you are out there as an employee or as a future HR professional, that you're not violating laws regarding compensation practices and the like. The first and most important one is the Fair Labor Standards Act, which basically defines who is or is not eligible for overtime, what is overtime, what is minimum wage, and it also gets at child labor practices as well. So, for example, who is exempt from overtime? Basically, professionals like lawyers and things like that, administrative, higher-end administrators, executives like C-suite executives in the organization, and outside sales. And there are certain thresholds that you'll see in your textbook that talk about, well, what does it mean? What is the threshold that needs to be met in terms of compensation to be considered an executive, and number of hours worked, and what the scope of their responsibilities are. And these are the things that guide us in that sense. This act covers organizations with a gross volume of sales that exceed $500,000. So if you make less than that, if your company has gross sales less than that, you do not have to comply with the Fair Labor Standards Act. Although I would always argue that it's a good practice to make sure that you are in alignment, because you never know when those numbers are going to go up. And the last thing you want to do is to have to change your practices and your policies based on suddenly having to comply with a law that you didn't do before. And it's very difficult to do that. So otherwise, anybody who works a certain number of hours with a certain rate of pay is eligible for overtime. What is exactly overtime? Well, it's 1.5 times the standard wage for each hour that you work over 40 hours. Now, some companies will pay you for lunch, which means then if you have a 40-hour work week, anything you do over 40, you will get, you are eligible for overtime. Some companies don't pay you for lunch, in which case that means if you are working 35 hours, that's considered full time. And then after that, you have to still work another 5 hours before you would start to be eligible for overtime. So you could actually have a 40-hour work week with your lunch plus 5 additional hours and still not get overtime. It really just depends on the company's policy and how it chooses to set up their pay structure. So be aware of that. Now, minimum wage is different. There is a federal minimum wage, which is $7.25 an hour. Now, if you were to do the math on that, let's do the math. I'm going to do this on my phone while I'm recording this. And so we've said it's $7.25 an hour times 40 hours a week times 52 weeks a year. That's $15,000 a year. So what that is arguing is that's the minimum that people can expect to get paid and make on an annualized basis with no overtime at the federal minimum wage. Now, think about that. Can anybody afford to live, particularly in this day and age and in this economy, on $15,000 a year? It's not a lot of money. Considering that rent is sometimes $1,000 or more a month, you've just eaten through most of your pay, because that would be $12,000. So minimum wage is a big issue in economic theory, because often it has been argued that setting a minimum wage hampers organizations from finding an equilibrium point in terms of wages to pay. But what we also know is when people don't have a reasonable income to be able to participate in the labor market and in the commercial market, right, to be able to buy goods and services that they are involved in creating, that hampers the development and the advancement of our economy. So having a minimum wage It actually can be beneficial. And I still argue, obviously, that $7.25 at the federal level is way too low. And there are many states that have increased that. And Illinois is one, Washington State is another, New York State is another. There are many that do, but many that stick to the $7.25 minimum. And the important thing to note is we want people to be able to survive and thrive, to be able to participate in the economy, to buy goods and services, to be able to pay their rent, to have safety needs. Let's go back to motivation theories, right? We talked about motivation theories a few modules ago where we were addressing Maslow's hierarchy of needs. If I don't make enough money to feel safe, I will never reach a sense of actualization or a sense of having meaningful work because I'm still not making enough. I can't even focus on those things when I am not able to pay the bills. So if you click on that link where it says minimum wage by state, you will actually be able to go to a web map on the Department of Labor's page that shows you what the minimum wage is per state. So you're aware where you might be living and working. The Fair Labor Standards Act also addresses that employees have to keep a record of non-exempt employees, their names, addresses, birth dates, sex, occupation, hours worked, regularly hourly rate, overtime earnings, and other information that's relevant for pay, because again, we want to be able to track whether or not people are being paid fairly, and making sure that there's no discrimination in the pay and labor area. As well, it addresses child labor. It makes sure that under a certain age, children are not allowed to work. That has been stretching a bit. It used to be 16. Now many states are allowing kids to work as early as 14 or 15. And this has some pros and cons to it. Obviously, the pro is, that it gives kids an opportunity to make money. But the con is, of course, children are not able to juggle working, even a part-time job and going to school full-time. Their full-time job should be going to school and learning and getting the knowledge they need to be able to more fully participate in the labor market later on. Nonetheless, the strength of it is, of course, again, as I said, people get the opportunity to make money, and I can hire people to do work. But we want to just make sure that we're paying people fairly, that we're not putting children in dangerous jobs, certain jobs they're not allowed to do if it requires driving, and if it requires, if it's a dangerous job, for example, deemed by OSHA, which we will get into OSHA laws in this module as well, and workplace safety laws. So, for example, when my daughter was under the age of 18, she couldn't work at Sam's Clubs because she would be exposed to forklifts, and forklifts are considered dangerous, and you have to be licensed to be able to and trained to use a forklift, and so they don't want anybody in the workplace who's working there who may have to use a forklift if they're not legally allowed to or safely allowed to do that. Other benefits, legal issues around benefits, for example, is the Pregnancy Discrimination Act, which covers pregnancy and childbirth. It is considered a benefit so that people are allowed to treat pregnancy like any other kind of short-term disability, that they are allowed to have time off, paid or unpaid, depending on the company policy. But if a health care benefit is offered, the company must cover pregnancy, and it must allow for pregnancy to be treated like any other short-term disability, because people are not pregnant forever. It's a short-term situation, and then people return to work. The Americans with Disabilities Act, again, we also address this in other materials, but specifically how it relates to compensation has to do with a workers' comp history. And if you have a history of workers' comp accidents, like you've been hurt on the job, the employer cannot investigate that and say, well, you've had all these workers' comp claims, regardless of whether or not you were innocent or guilty in creating these accidents. we're not going to hire you because you are more likely to have a workers' comp claim. You can't do that. Now, if someone's abusing workers' comp and they're really not injured, that's a different story. But if someone is legitimately injured, they're legitimately protected under the law, you cannot inquire about their past workers' comp history if you are going to be hiring them for a particular job. So, because that's protected under the Americans with Disabilities Act, because they are temporarily disabled if they're on workers' comp. Lastly here is Family and Medical Leave Act. The Family and Medical Leave Act basically says we will provide 12 weeks unpaid leave for serious illnesses, or birth or adoption or foster care of a child, or the care of yourself, a child, spouse, parent, close relative, defined under the law. So you're allowed to take 12 weeks of unpaid leave, and this is again a benefit that is offered to employers if you have employees if you have 50 or more employees within a geographic area, 75 miles. And we are obligated to allow them to take time off to deal with healthcare issues, child issues, things like that. Other benefits and legal issues. The Age Discrimination in Employment Act that we've discussed before argues that we cannot have differential benefits for those over 40. We can't charge them differential rates. We cannot require them to have different standards than we would for anybody else. And so it protects people who are over 40 from having benefits denied to them because of their age or because of maybe other differential reasons. So everybody gets treated the same with respect to age benefits. ERISA is a law regarding pension plans and how we protect our pension plans. Like the FDIC protects deposits in banks, the PBGC, the Pension Benefit Guidance Protection, requires us to protect our pension benefits that are set aside for our employees. Employees have a non-forfeitable right to 100% of their accrued benefits after 5 years. So when you hear people talk about being fully vested, that means that they've worked for the company for 5 years, they are now fully vested, and they are allowed to get 100% of their pension, whether it comes to them when they retire or it gets transferred to another employer in a lump sum, depends on the way it's set up. But it restricts what companies can or cannot do or must do with respect to the pension plans. The goal is, right, to protect people's pension, to make sure that they are invested properly, that they are not being frittered away and wasted on poor investments. Sometimes bad things happen. People who were part of Enron a number of years ago, when that company folded, they lost their pensions. And there's nothing you can do about it if a company folds. But when a company is not folding, when they have behaved accordingly, people should know that their pension fund is protected appropriately. Anybody who leaves a company in less than 5 years will usually get a prorated proportion of their pension fund. So if you work for a company for a year and invested for a year, you get 20% of that. And if you've invested for 2 years, you get 40%. If you invested for 3 years, you get 60, 4 years, 80, 5 years, you get the full 100% back. Lastly is the Economic Recovery Tax Act. Allows for pre-tax money to be set aside for dependent care. It also, those kind of rights have been extended for transportation costs as well as for medical spending. So we can use pre-tax money, which decreases our tax liability, which is always good for anybody if you can do that. We also have a thing called the Consolidated Omnibus Budget Reconciliation Act from 1985, which is also known as COBRA. You've probably heard of this term before. COBRA requires private employers to make sure health benefits are made available to somebody who has retired or has been terminated for any reason, or have left the company for any particular reason, and they offer those benefits to the employee for up to 18 months. Sometimes it gets expanded, but generally speaking, it's 18 months. And doesn't mean that the company pays for those benefits, but it offers the benefits to the employee at a group rate, which is a significant discount from buying the benefits on your own out of your own pocket. I mean, I know back in 1990, late 90s, I was offered COBRA, and it was over $1,000 a month for me to buy insurance through my COBRA. And that was a lot. Then it's even more now, and so again, you have to be making $15,000 or more a year to be able to pay for healthcare benefits. So that's quite challenging, obviously. Lastly is the Health Insurance Portability and Accountability Act, or HIPAA. And anytime you've gone to the doctor, I'm sure you've heard your doctor say, here's your HIPAA, guidance and the policies to make sure you know that your health records are being protected. And that also eliminates restrictions on what we call pre-existing conditions. Now, that got expanded under the Affordable Care Act that was passed in 2010, which we'll see in the next slide. But originally, this was a compromise that was done in 1996 when President Bill Clinton was not able to get insurance reform passed. What it did is it said, if nothing else, we want to make sure that people who have a pre-existing condition, for example, if you have diabetes and you work for a company and you now move to a new company, companies used to be able to say, well, we're not going to cover your diabetes medication. We're only going to cover you under these certain conditions. And again, what we're doing is we're creating discriminatory behaviors towards somebody who has a chronic illness. And it was considered discriminatory, and there was no reason why they could not be covered by that. So now, because of HIPAA and because of the Affordable Care Act, you are allowed to be mobile from job to job. We didn't limit people and say, well, if you left this job, you would lose your health care benefits or lose parts of your health care benefits, which again is discriminatory. It then would limit the mobility of somebody to go to a better job someplace where they got treated better pay, better benefits, those kinds of things, better working conditions. And it ensures that no matter what, no matter where they are, they will be covered as a pre-existing condition. So in follow-up to HIPAA, President Obama in 2010 was able to pass the Affordable Care Act, which again reiterated that people with pre-existing conditions are covered, that insurance companies are required to cover adult children up to the age of 26 on their parents' policies. Many of you are probably still on your parents' policies, but once you hit 26, you age out. Some insurance plans provide 100% coverage for preventative services. So if you go for your preventative dentist care or preventative medical care, your annual checkups, that's covered 100%. Insurance companies will be required to price and sell policies to everyone, regardless of health status. So we are not saying that you cannot get insurance because you're sick, which makes no sense, right? Because we want people to be healthy. So we would want to provide them with insurance to be able to do that. Federal subsidies are available, or at least were available. They were going to be less so available now under the big budget bill that President Trump passed in 2025. But there used to be subsidies, and there may be some still at some state levels, but across the board, not too many. Nearly all Americans will be required to have health insurance or be taxed on it. And so the goal is we want everybody to be on insurance. We want everybody to be healthy. We want everybody to have the right to have access to health care. Some people don't want it. I don't know why they wouldn't, but they don't want to have to pay into a system to do that. So that is their choices. But the tax has been upheld in the Supreme Court. So even if you don't have insurance, you will get a tax. When you pay your taxes every year, you're asked, do you have reportable insurance plan, and that is considered legitimate? And if so, then yes. Companies with fewer than 25 employees may be eligible for tax credits to help the insurance for their employees. Companies that have 50 or more workers and that don't provide insurances may be fined or taxed. And then federal regulations require insurance to have minimum standards. Some of those standards have varied from when they were originally passed in 2010. For example, there was a Supreme Court case regarding birth control benefits, and some companies refused to pay for birth control in general or some forms of birth control. Nonetheless, there are some standards that need to be met. And unfortunately, that became a big controversy when it was passed, because everybody's like, if you have your insurance and you like it, you can keep it. In which case, then once they set those minimum standards, some of those policies were not adequate enough, and people lost those policies. So that made them unhappy, and understandably so. So that Affordable Care Act was a big, huge benefit, and it is in the law passed in order for people to make sure everybody has access to it. And it creates a marketplace in some areas. So every state has their own marketplace, or most states do. There are some that choose not to participate in it, but some states have these marketplaces where you can go and get reasonably priced health insurance. Executive Order 11246 has been repealed by President Trump. It was one of the first acts that he engaged in on his first day in his presidency. And it was affirmative action. And it was affirmative action, and it was dealing with all sorts of issues regarding ensuring that there was equal opportunity for access to jobs, and that everybody had equal access to jobs. Job opportunities. It didn't say that you had to hire unqualified people, but it basically said you had equal access to be able to get into positions, and you got offered the same opportunities. That being said, there are some issues with the OFCCP. We haven't gotten full guidance from the OFCCP on how to handle some of these issues, particularly around employment discrimination and compensation. So that is something that still needs to be addressed, which is why we're sort of still talking about it here. National Labor Relations Act also deals with pay, making sure that we have pay transparency, that people have the right to discuss pay as part of collective bargaining. You could even extend that to say you really can't tell an employee that they are not allowed to talk about their pay in private organizations, although many organizations will say it's against the company policies to talk about pay. You can probably argue under the National Labor Relations Act that I have the right to talk about pay, because as an employee, even if I'm not unionized, I'm still protected by some of those elements of the National Labor Relations Act, meaning I'm allowed to talk about my pay. I'm allowed to discuss that with my colleagues to address this. You don't have to have a union in place to be able to do that. And then lastly, the Internal Revenue Code is a big issue with respect to income and payroll taxes, and how income and payroll taxes get managed and handled. And so that's always important to make sure that we are paying adequate income and payroll taxes to the government, to the employees, to the states that they are a part of, if there is a state tax involved, and making sure that those benefits are properly taken out of pay and properly sent forward to the administrating bodies.